in terms of Section 103, Final Control Act 60 of 2000.
So this, if I consider a deportation order and accused number one
yes, Your Worship.
to pay for his own airfare.
Yes, Your Worship.
You have indicated that he's in a position to pay for his own airfare.
Yes, Your Worship.
And
My attorney was delayed, Your Worship, Mr. Nguni. He's in Pretoria, and he had told the court that he's going to be delayed. Things went later than expected, but he's made all the necessary arrangements, both financially and the booking of the tickets, to facilitate that.
For today.
Yes, Your Worship.
Thank you. The court then proceeds for sentencing. Sentencing involves exercise of discretion. This discretion must be exercised judicially. In other words, all relevant factors and circumstances must be considered. Now, number one, Mugabe, you are 29 years old and you are a first offender. Number two, you are 32 years old and you are also a first offender. Both of you have strong family ties and have spent more than 2 months in custody awaiting trial. Both have indicated right from the start that you wish to plead guilty. It is not every day that persons plead guilty in original courts, where harsh punishment are the rule rather than the exception, especially for firearms and violence-related offences. They both follow English. Now, the complainant had also been amply remunerated for the injury he sustained. The remuneration was to such an extent that the complainant wanted to withdraw the charges. With the complainant not at all keen to proceed, the accused's decision to plead guilty must be viewed as a definite mitigating factor. Now that I say with experience in mind. Recalcitrant or unwilling complainant can be quite a handful. And quite often it does not result in a conviction because of that very same reason he is unwilling to give his cooperation. So I will view it as a definite mitigating factor. Now, not much is known about the incidents themselves, except for the elements of the crimes which were admitted. It was also alleged that number one was present when the attempted murder was committed. The court does not know much of the surrounding circumstances leading up to the shooting and the full extent of the injuries. I'm not going to speculate as to why. The court will also consider the fact that the accused too defeated or obstructed the course of justice by concealing or disposing of the firearm involved. It is quite a serious offense. The firearm is also still in circulation. I don't have to say much about illegal firearms and violent crime. It speaks for itself. If this weapon was tested to be a 9mm pistol or semi-automatic weapon, a minimum sentence of 15 years imprisonment would have been applicable. That is just to illustrate the seriousness of the offense. However, the court can't speculate in the absence of that as to make and caliber, and a minimum sentence is not applicable. All the firearm charges are extremely serious. Regarding count 3 and 4 sentences, up to 15 years are the rule rather than the exception. Mr. Otis will tell you that. Even count 4, the pointing of a toy gun under circumstances likely to lead a person to believe it is a firearm can be visited of a sanction of direct deposit up to 10 years. Mr. Mugabe, that relates to you. Now, immigration laws are also there for a purpose. I'm not going to dwell much into it. Every country has them and they need to be respected. Now, both of you could have renewed your permits with the greatest of ease. So, I will take that into account. Both of you, as I said, are first offenders. Both of you are showing remorse, and I'm prepared to accept it as genuine remorse. Now, hence the restorative justice or remuneration of the complainant. Both of you, hopefully, learned the simple wording. During this episode, respect for oneself, that is for you, yourself, the governing laws of the country, and respect for the dignity and rights of others. The court will blend the sentence with mercy. Mercy, however, is a balanced process of thought and must not be confused with maudlin sympathy. And I also got a duty in my profession to balance not only the right of the rich and the famous, but also the normal Zimbabweans who are here. Everybody must know they're going to get a fair sentence. Now, fairness and mercy is not maudlin sympathy. Mercy is a balanced process of thought. And as far as number 1 is concerned, Mr. Mugabe, after careful consideration, due to the lesser charges, I'm of the opinion, and before I do that, I'm going to say this. I do not know whether the second accused took the rep for you. And I can only act on what is before me. Number 2 pleaded guilty on all these counts. So I don't know. But nevertheless, I will proceed with sentencing on the counts as they were proved. Number 1, as far as count 5 is concerned, you are fined to 400,000 rands or 24 months imprisonment. That is now the pointing of the toy gun or that was likely to lead the person to believe it was a firearm. As far as count 6 is concerned, that's the immigration law, 49, section 49(1)(a. You are fined 200,000 rands or 18 months imprisonment. It is also ordered that you be deported. You will be escorted by the investigating officer who is here at court today and who must be complimented for that. It's not every day that we encounter that in the regional courts anymore. So he will escort you to our Tambu to oversee your departure today. So no order is made in terms of section 103(1) of the Arms Ammunition Act. You are deemed unfit to possess a firearm. I will then now proceed with accused number 2. Or before I do that, number 1, Mr. Mugabe, you can count yourself very lucky that the complainant in your case was not injured. Normally, fines are inappropriate in immigration matters. However, you are in a position to pay for yourself, alleviating the department or the state from the duty to deport you. Mr. Matonzi, number 2, you had been convicted on very serious counts. Attempted murder, defeating and or obstructing the course of justice by concealing and or disposing of a firearm in question, the illegal possession of firearm and ammunition. As I've mentioned, all these offences are offences where direct long-term imprisonment, I'm talking 10 to 15, even longer, are the rule rather than the exception. The fact, as I said, that the complainant was remunerated, together with all the other mitigating factors already mentioned, will definitely soften the effect of the sentence. As I said, from my experience, and I am here in Alexandra now for 26 years, and I'm in the regional court probably for about 50 years. If a complainant does not want to continue with a case and accused plea not guilty, a conviction is seldomly achieved. So it took some guts from you to plead guilty to all these counts. So basically what you did is you put yourself, number two, at the mercy of this court by pleading guilty. So that says quite a lot in your favor. So the court, with regard to you, is of the opinion that the following is a well-balanced sentence. And normally, direct long-term imprisonment is applicable for these offences. You're not going to escape jail today. So, the court is of opinion that the following is a suitable and well-balanced sentence. It's going to be a merciful sentence. As I said, mercy is not model sympathy. As far as count 1 is concerned, you are sentenced to 12 months imprisonment. Count 2, you are sentenced to 12 months imprisonment. Count 3, you are sentenced to 3 years imprisonment. Count 4, you are sentenced to 12 months imprisonment. The court orders that all the sentences be served concurrently. It is further ordered that you be deported once the sentences are served. Do you all understand? Mr. Mugabe? Mr. Matonzi? Good. So the gentleman, Mr. It was Colonel, if I remember correctly.